Before the court today is a motion for reconsideration of the court's prior order granting summary judgment. Mr. Morgan, this is your motion. You may proceed.
It is. Thank you. I want to thank the court for hearing this reconsideration motion today. I know that these are disfavored by the court, and I appreciate the court giving me the opportunity to have this hearing today. Before the court is actually a very narrow motion for reconsideration. The purpose and focus entirely on the Washington Consumer Protection Act portion of the May 11th ruling. And I want to point out that opposing counsel has indicated in some of what their filings were that the Consumer Protection Act, the Washington Consumer Protection Act, is meant to be used when there's no other legal or procedural remedies available. And if they had no other relief under any other statute, then there's maybe a distant possibility that there could be some applicability in this case. However, they already have relief available for the actions that the defendant would have taken regarding the robocalls from 2016. One of them, of course, is filing a complaint with the Public Disclosure Commission, which was done and found to be without merit by the PDC, but that's a remedy.
I need you to slow down, please.
Apologize.
Filing a complaint with the
Public Disclosure Commission, which was done and found to be without merit by the PDC. Two, and more germane to this hearing, was the court's original January 2016 ruling from last year that the defendant violated the Telephone Consumer Protection Act, which is a federal act entirely separate from the Washington Consumer Protection Act. The WCPA claims brought by the plaintiff are redundant, and they're double dipping, and they're not allowed under the WCPA itself due to the original ruling by this court last year on the TCPA violations. The plaintiff should not be entitled to get attorney fees or additional double or treble fees under the WCPA, and they must be content at this stage with the relief already granted to them by this court and the statutory fees attached to that original ruling.
Mr. Morgan,
yes.
My apologies for the interruption. On that point, wouldn't the court have the opportunity to determine the appropriate remedy and address that concern about overlapping remedies?
The court does have that opportunity. I don't believe that we've fully explored that yet, so I would agree with the court on that. And one of the things I wanted to point out here is that the plaintiff's attempt to expand the scope of the original charges, which is what we are looking at here. These it's double dipping their charges. They came in the guise of an amended complaint over a year after the original TCPA ruling by this court. And they're not appropriate entry for summary judgment on what I believe is such a novel and unusual case of first impression. The plaintiffs wish to confuse this court with a variety of listings of TCPA cases, which are the Telephone Consumer Protection Act cases, and then attempt to claim that those cases have any relevance to their expansion of the original complaint to include WCPA claims, which are duplicative. They're duplicates of the original TCPA claims. There's no additional activity other than what the original TCPA claims were made by the court. When the plaintiff does use cases to support their WCPA claims, without exception, every case involved commercial activity of some kind or another. There are no records that can be found enforcing the WCPA by any court that's ever been issued in the state of Washington. I've never been able to find one, and neither has the plaintiff. And applying that to a political activity, it's just never happened before. And this is alone is what makes this narrow request, just on that issue on the WCPA from May 11th, it's a case of first impression. It has never been applied to a political activity. And the reason that it has never been used is the courts would be obviously flooded with cases that extend the statute into an area of the law that has never been intended to be applied to. And that's not the only reason. The other reason is that the state of Washington already has assigned statutory authority to prosecute violations in the political arena for robocalls for all kinds of activities in the political space under RCW 4217A.
Well, again, please.
Under RCW 4217A with the Public Disclosure Commission. Nobody has ever used the Washington Consumer Protection Act. There's no case history that I can find for political activity of any kind before. And I think this court should very carefully consider that fact while reviewing this decision. And I'll reiterate what I stated in my motion for reconsideration. Even under the authority granted to the PDC in state law, The Supreme Court has been very consistent in even those cases where the Supreme Court has ruled the PDC was beyond its scope to enforce even outright lies and deceptive practices, far worse than anything alleged by the plaintiff against the defendant in this case. And this court has already given the plaintiff what they need. They have relief under the TCPA. There are statutory fines under that, and under the WCPA. And while we can appeal and continue to dispute those maybe at a future date, expanding the WCPA into an entirely new territory where it has never been applied in the history of the statute is something that should be explored at trial, which the plaintiffs would still have the ability to explore if they choose. It's unsuited for a motion for summary judgment. In summary, I just ask this court to reconsider just that narrow portion of the May 11th summary judgment ruling on the WCPA claims brought by the plaintiff in their amended complaint. It would be a case of first impression that isn't appropriate for a summary judgment ruling. It expands the WCPA as into political activity where it has never once been applied before. The WCPA is a statute to be applied when no other laws and relief already exist, and the plaintiffs have already obtained relief under the TCPA claims by this court. And finally, in applying the WCPA to what is clearly and unarguably and indisputably a political speech case, the plaintiffs alone say that it's deceptive. They're saying they don't like what was done. They say that the speech was deceptive. And I'll dispute that, but that's what they're saying. That even if they don't like how the robocall numbers were used or the messages involved, the Supreme Court has ruled that the state is in no position to attempt to infringe free speech like this. I believe that my written brief is accurate and thorough on this, but those are my oral arguments in this case, and that's why we're here today. And I do appreciate the court's willingness to reconsider this element of it.
I have a couple of questions, if that's okay.
Yes.
My first question is going to ask you about this claim, kind of the flip side of what you're arguing. It appears that your argument is that the Consumer Protection Act can't apply in this context of political advertising. Is there any case law, any authority, any precedent for this court to follow that holds that the Washington Consumer Protection Act does not apply to political advertising?
We're really looking at a vacuum in case law that I can see. As far as the case law that exists on political advertising usually applies to 4217A applications, usually under the Public Disclosure Commission. It's where the arguments in this area have been that have gone before the Supreme Court. I can't find any case law where the WCPA supports it. All case law that exists, it exists to apply to commercial activity, which is one of the reasons why I argued in my brief that it fails on its commercial activity. The plaintiffs aren't arguing that I had a false contract with the robocall company, with Dialing Services LLC. They aren't saying there's something wrong with that or misleading with that contract. They're saying that they didn't like how it was implemented, that the message out there they did not like. They didn't like that 3 of the 5 calls had different phone numbers they didn't like. They're arguing that the message that it contained they didn't like that. I can't find any case law that supports using the WCPA for this, and it doesn't look like that when you read the statute very carefully, as I've read it now numerous times. The statute can't be applied in this case. There's no commercial activity, there's no profit motive, there's no, it's entirely a political speech case.
Right, but my question was different than what you're arguing. My question is, I issued this order based upon the Consumer Protection Act applying because I didn't look at the context for that particular claim, because there doesn't seem to be an exception that I'm aware of in the case law for political activity.
So when I filed my brief for reconsideration, I brought up a couple of cases, though, that I felt were as close to relevant as I could, which were Supreme Court cases. One from 2007, and it was the Rickert, I'm going to pull it up here so I actually correctly reference this, but it was the Rickert versus State Public Disclosure Commission case from 2007 before the Supreme Court. There was a second one that this actually built on, which was the PDC versus 119 vote no committee. And both of them were similar in the sense that rules had been actually explicitly written to constrain the content of speech during a political campaign, specifically. And in these cases, particularly the Rickards case, you had somebody who actually pretended to be from an entirely different party and represented themselves as such. And it was found to be a complete lie, and it was generally agreed upon that that was deceptive. The Supreme Court, though, ruled that it wasn't the state's authority to come in and make a determination as to whether or not that was good speech or bad speech, because they were quite nervous. And Jim Johnson, who wrote the final decision here, was very clearly where he said, if the state cannot substitute its judgment as to how best to speak for that of speakers and listeners, free and robust debate cannot thrive if directed by the government. By implication, we're really applying the WCPA here in a very similar way that I think would be contrary to how the Supreme Court has ruled in cases that have been brought before it like this. There was a recent case that I referenced as well out of Spokane Valley that had to do with another free speech. It was brought as a freedom of religion case, but actually it ended up being decided on a free speech case. And in fact, in that case, the Supreme Court actually chided the attorneys for not referencing the Washington state constitutional protections on free speech, which they said were actually more robust than the federal free speech rules. And when I looked at these cases, they really do seem to apply to the Washington Consumer Protection Act. And even though it's dealing with a slightly different body of law, it's still the same outcome that we're really looking at, which is the chilling of free speech and using this law, Washington state law, to punish free speech in this case. The TCPA is different. There is a different case history that has been used to penalize people who have been involved in political campaigns. I think there's a different argument that I would have there on that. But since that's not the scope of today's hearing for the reconsideration, then I'll save that for another time.
Thank you.
Do you have any other questions, Your Honor?
That's all for now. Thank you, Mr. Chairman.
Good morning, Your Honor. The court properly granted summary judgment both on the TCPA and Washington Consumer Protection Act claims. I think that the court's initial question to Mr. Morgan is spot on. There is no exception in the Washington Consumer Protection Act that carves out or gives some special treatment simply because somebody happens to be engaged in political speech. And the court also correctly noted, and I think has been reiterated several times here, this is not a case about the content or the substance of the political message. The court has never weighed the truth or falsity of the message. The plaintiffs have never contended that the contents of the message were true or false. At issue here is the content-neutral, unlawful mechanism that the defendants utilize to spread their message, whatever it may be. And in that context is where we find the violation. Even though these facts don't touch upon the content or limiting somebody's speech or what they have to say, the constitutional arguments place a heavy burden on the defendants to show that the Washington CPA is unconstitutional or being unconstitutionally applied here. And they're simply not able to do so. There is no authority for the proposition that political speech enjoys additional protections under the WCPA. This is not a case where someone is using the WCPA to criticize the content of one's speech.
But isn't this CPA claim sort of a way of bolstering the other claim that you did bring? So there's somewhat of an overlap, wouldn't you agree?
I think that's fair, Your Honor. And the problem with the defendant's argument is that Congress expressly authorized that kind of overlap. Part of the FCC's regulation-making process and Congress's lawmaking process is to recognize that A, the FCC can't police every violation of the TCPA, and B, that states, should they choose, should have the ability to enforce those more vigorously than the federal government may be able to. And the states can do so as long as it's consistent with their own state laws. And in this instance, Washington has a Consumer Protection Act that essentially employs private attorneys generals to enforce the rights of Washingtonians more vigorously than might otherwise be allowed or appropriate under the TCPA. And that's precisely what's happening here. So to the extent that does bolster or further support the claimed remedies, I don't think...
I need you to please slow down.
to the extent that bolsters or extends the remedies under the TCPA, I would say that that's precisely what Congress intended and what Washington, exercising its own state's rights, has decided to do in this situation by making additional enforcement remedies available. On the constitutional grounds, again, this is not about content of speech. Even so, defendants failed to address any of the authority indicating that these are content-neutral time, place, and manner restrictions. We pointed out in our brief that the mere fact that political speech may be somehow involved in communication does not somehow insulate the speaker from all other laws. We made the point that the peaceful protester can still be a trespasser, the graffiti tagger can still be the vandal, the robocaller can still be liable under the TCPA and the WCPA, political speech, message, or otherwise.
Mr. Gilman,
Yes, Your Honor.
you've made allegations throughout this of deception, and I just want to clarify your use of that term. It appeared to me, and perhaps I was incorrect, that your allegations here were pertaining to methods and in other words, that these calls, the deceptiveness was in where they might have originated, not necessarily in the message contained, but I want to be clear on that. That the use of the word deceptive.
That's absolutely correct, Your Honor, and we've reiterated a couple of times. The deception here is the spoofing of caller identifications, the failure to properly identify, the commandeering of other people's identities or phone numbers and so forth, and concealing the messenger, which federal law and the state law that would follow says that you need to be open in disclosing that. What Mr. Morgan or his companions had to say about the political candidate or how people should vote or anything like that, we're not saying that's part of the deceptive conduct here. I think another important point here is that what the WCPA precludes is unfair or deceptive conduct. This is also unfair within the meaning of the TCPA because it violates other statutes, other regulations that prohibit precisely this kind of conduct. So it is actually an or proposition, but the court is correct. When we say deceptive activity, we are not talking about the truth or falsity of the message that was delivered, simply the manner and mechanism in which it was delivered that is the problem. Mr. Morgan has commented on RCW 4217A. I don't think that was mentioned in the briefing. What I'll simply say here is that the defendants have cited no authority or provision that says that that is an exclusive remedy, that anything having to do with campaigns can only be addressed under that statute. I don't think that's the case. And the mere fact that there's other laws that may have been violated or not has no bearing on whether a WCPA claim can go forward. I think the court ruled correctly. I think that it's clear in this situation that the violation goes to the violation of general laws that prohibit spoofing caller IDs, robocalling cell phones, failing to identify oneself, failing to provide a callback number, using artificial or pre-recorded voices in those messages. None of that has anything to do with the content of the political message that was being delivered, and the mere fact that a political message was being delivered does not insulate the defendants from their violation of the law. So I think the court's original ruling is correct and that reconsideration should be denied.
Thank you. Mr. Morgan.
I wanted to clarify here that the entire case by the plaintiff has, from the beginning, in every written document, provided an explicit analysis of these robocalls as being deceptive and dishonest in some way, which directly goes to the heart of the message. The original complaint brought before this court outlined what the message was. The plaintiff has said that I have failed to identify myself on these robocalls, which is not true. I did identify not just myself, but the committee that paid for it, which is required under RCW 4217A, which is what the Public Disclosure Commission requires for identification. I did identify it. In the three cases that he's talking about here, I had referenced, because it was my voice on that robocall, saying that to call back the phone number here to let them know that racism should not be supported, for example. And while that may be an argument of the TCPA of a violation under that, that is not grounds for a WCPA claim here. And repeatedly throughout both the original complaint and the amended complaint, there was an attempt to say that these were deceptive or dishonest messages, which goes to the heart of what it was, which was a political communication about an election and about an elected official and about large and unusual donations to that elected official during that time. The constitutional protections that do exist for free speech do not get waived. They don't get waived just because somebody doesn't like what the message was. And the Supreme Court, I think it's Washington State Supreme Court, has been very strict in upholding some of these cases. I also want to point out, as I referenced in my original brief on Article 1, Section 32, about going back to original principles, if we're going to open up the door, and I think it's a Pandora's box of some kind, well, we're going to say that now, if you just don't like the message that somebody has or the way that they delivered that message, and there's arguments about this in the political space all the time, your signs were placed in a way that was deceptive, your mailer came out and I didn't like how that image was photoshopped. There's all kinds of ways now that the court would be opening up the WCPA to apply to claims in the political space. I don't believe that was the intention of the legislature when they passed that. And I don't believe that those claims would be upheld before a higher court, for sure, or should be before this court either, on just constitutional protections alone. That is a very high bar, and we're reluctant to go and impose those on people to chill free speech. And I believe that is why this is an important reconsideration hearing to have. Again, I'm very narrowly focused on the WCPA elements of this. There is relief already being granted to the plaintiffs under the TCPA. There's also relief potential for the plaintiffs under the Public Disclosure Commission if what they said was accurate and that I did not identify myself correctly in those robocalls. They would have the ability to file a complaint with the PDC, which was done, and it was dismissed. So the part of this complaint isn't accurate in the first place, that there was anything deceptive related to that. But again, the motion before this court is a very narrow one, focused only on the WCPA elements of this, and the fact that this does create a case of first impression where this has never been used in a political application before. I appreciate the opportunity to present this to the court, and I'd be happy to answer any more questions you might have.
I don't have any other questions. The court is prepared to issue a ruling at this time on the motion for reconsideration. As Mr. Morgan indicated, the court often issues rulings on motions for reconsideration without oral argument. Pursuant to the court's local rules, the court is allowed to do that after reviewing briefing and issue an order without oral argument. I did not do that in this case because I did want to hear from the parties, and I appreciate that this motion for reconsideration is narrow and doesn't address all of the points that the court addressed at summary judgment. It offered the court the opportunity to look closely at the Washington Consumer Protection Act claim individually and take a look again as to whether the court correctly decided that issue at summary judgment. Having reviewed that carefully and having heard from the parties today, the court is denying the motion for reconsideration. The court is convinced that at this point, rather than expanding the Consumer Protection Act and issuing its ruling, the court followed the precedent that the court is aware of that does not at this time allow for any exception for political activity. The court viewed the activities here in a content-neutral fashion for the purposes of the CPA alleged violation. That's the way that the court viewed it. And I appreciate that appellate courts in the future may decide this differently. It is an area that the court and the parties, frankly, struggle to find applicable case law that might impact this particular case. But the court feels that it followed applicable precedent that exists at this time in granting the summary judgment motion. The court also believes that although multiple remedies may be available to the parties, the court was not precluded from issuing the order that it did on the Consumer Protection Act claim, even though there may be overlapping remedies. That may be an issue that the court can address in the future, but the court believes that the order that was previously issued on summary judgment as to the Washington Consumer Protection Act claim was correct, and the motion is denied.
Thank you, Your Honor. I have a proposed order, which is essentially generic and simply states denied. I can hand forward to the clerk to accept.
The parties may agree to the form of an order today, or it may be presented at a later time.
Thank you.
So I would ask that Mr. Gilman, you allow Mr. Morgan to review that. If it's agreed as to form, I will sign it today.
Thank you, Your Honor.
Thank you.